substantial difference between your oral comments and written comments, that you keep your oral comments brief because we do already have your written comments on record. And with that, I'm going to go ahead and ask the applicant to begin their testimony.
Thank you, Mr. Director. Before proceeding with our opening statement of this testimony, I'm just going to introduce a couple of initial exhibits for this hearing. These are in the tab binders that you have in front of you. I've also provided more copies to the court reporter. Exhibit 1, and the tabs correspond to the exhibit numbers that I'll reference. Exhibit 1 is the Secretary of State Certificate authorizing Low Carbon Logistics, CCS Transport, LLC, to do business in Louisiana. Exhibit 2 is the Secretary of State Certificate authorizing Denbury Gulf Coast Pipelines, LLC, to do business in Louisiana. Exhibit 3 is prior PL order number 6046, dated January 30th, 2008, authorizing the construction and operation of the Green Pipeline, LA. And just through the course of this, just as a matter of procedure, we refer to the portion of the Green Pipeline in Louisiana either as the Green Line or the Green Pipeline, LA. If we're talking about, which we will briefly, the Texas portion, we'll refer to it specifically as the Texas portion. Exhibit 4, which is PL order number 6047, dated January 30th, 2008, issuing a certificate of public convenience and necessity to Denbury Onshore LLC for the Green Pipeline, LA. Exhibit number 5, which is PL order number 7187, effective February 28th, 2014, which authorized the transfer of PL order number 6046 and PL order number 6047 from Denbury Onshore to Denbury Gulf Coast Pipelines, LLC. Finally, Exhibit 6, which is PL order number 7203, which was effective April 17th, 2014, which issued a certificate of public convenience and necessity to Denbury Gulf Coast Pipelines, LLC for the Lake Charles Highway. All for file and introduce Exhibits 1 through 6 into the record of this hearing. And now Ms. McKibben will deliver a short opening statement.
Is that better? Sorry. Good morning, and Mr. Commissioner, I know that there has been a reorganization. We should probably call you Mr. Director, but we will probably lapse. I'm Marjorie McKibben with Jones Walker Law Firm, here along with my partners, Justin Morocco and Lauren Mastio, representing Low Carbon Logistics and Denbury Gulf Coast Pipelines here today in this docket, in which we are seeking to amend and assign a certificate of public convenience and necessity which had been previously issued. The certificate is currently in the name of Denbury Gulf Coast Pipelines, and Denbury and its affiliate Low Carbon Logistics are seeking to assign the certificate as amended to Low Carbon Logistics. For clarity, based on some of the comments received, we want to point out a few things about this filing. First, although we are requesting an amendment of the existing certificate, it will essentially be an amendment and replacement of the existing certificate. By amending and replacing the existing certificate, there would only be one surviving certificate, not two out there for essentially the same service. In doing so, Low Carbon Logistics is complying with all notice and all procedural requirements and making a showing that it satisfies all legal elements set forth in Louisiana Administrative Code Title 43, Part 11, Section 3501G, exactly the same as if it were applying for an application for a brand new certificate. Its actions are fully in compliance with the Louisiana Revised Statutes 30:4 C-17 and Louisiana Administrative Code Title 43, Part 11, Section 3501. This is not a shortcut. We just want to address some of the concerns that we will be proving every single thing, or attempting to, that would be required and is required if we were getting a brand new certificate. Procedurally, it just seems to make more sense to proceed this way so that there are not two certificates for the same destination. Second, as the Commissioner knows, neither the existing certificate nor the amended certificate would authorize either construction or operation of the pipeline. Certificates do not authorize construction. A separate order from the commissioner is required for actual construction or for actual operation. Now, back when the existing certificate was issued in 2014, Denbury did acquire a separate order authorizing it to construct and operate the pipeline. However, as the commissioner knows, orders to construct and operate expire after 1 year if no construction or extension is received. The separate order authorizing construction and operation of the pipeline has expired, and we are not seeking a new order to authorize construction or operation at this time in this proceeding. That would have to be a separate filing and a separate proceeding. So to be clear, nothing we are seeking here today would allow construction or operation of a pipeline. And now Mr. Morocco will proceed with the testimony of Mr. Rocco.
All right, Mr. Rockby. All right, Mr. Rockby, you've previously been sworn in. Can you state your name and current occupation for the record?
My name is Daniel Rocker, and I'm the onshore pipeline projects manager for Exxon Global Projects.
And can you give the director a brief rundown of your background and history with Exxon?
Yes, I was hired by Exxon Pipeline Company in 1990, which means over 35 years now with Exxon Mobil. I spent 17 years in the pipeline company. By education, I have a Bachelor of Science in Mechanical Engineering from the University of Texas Austin, and a law degree from the South Texas College of Law and Houston.
Excuse me, sir, could you move the microphone a little closer?
Yes.
Thank you.
And I started with ExxonMobil Global Projects Company in 2019. When I was the Pipeline Improvement Initiative Senior Project Manager between 2019 and 2023. In that job, I managed the development and execution of over 500 miles of pipeline installations in North America. And as I said earlier, I'm the onshore pipeline projects manager. I was assigned to this position in 2023. In this job, I applied learnings and best practices from my prior assignments to ExxonMobil's global onshore pipeline portfolio.
And can you just further describe what's encompassed in your current role as the onshore pipeline projects manager?
Yes. In my role as onshore pipeline projects manager, I manage a team that specializes in planning and development of onshore pipeline projects for ExxonMobil's global pipeline portfolio. That involves route identification, engineering, permitting, right-of-way acquisition, procurement of materials, safety and construction expertise, along with quality oversight and documentation. And as part of my normal job responsibilities, my team also provides support to ExxonMobil's affiliates and subsidiaries.
So in your current role as onshore pipeline projects manager, you're familiar with both of the present applicants of carbon logistics and Denbury Gulf Coast pipelines, correct?
Yes.
All right, and are you also familiar with their current pipelines and operations?
Yes.
All right, in your current role as onshore pipeline projects manager, did you help provide the information for and assist with preparing the applications that are the application that is the subject of the hearing today?
Yes.
Okay. And did you review the filed version of the application, which was marked as State Exhibit 1?
Yes.
Is the information contained in that application, which was previously marked as State Exhibit 1, true and correct to the best of your knowledge, information, and belief?
Yes.
All right, if you can turn to tabs 7 and 8 in your binder and identify those for the director.
Exhibit 7 is a list of current officers of low carbon logistics. And Exhibit 8 is the list of current officers of Denbury Gulf Coast pipelines.
And I'll also file and introduce Exhibits 7 and 8 into the record for this hearing. Now, if you can turn to Exhibits 9 and 10 and identify those documents.
Yes, Exhibit 9 is the current financial statements of ExxonMobil Pipeline Company, LLC. Exhibit 10 is the current Form 10-K for ExxonMobil Corporation.
And Mr. Director, as I mentioned before the hearing began, in your binders is not a copy of the 159-page Form 10-K, but I've provided a single copy for the dais for this proceeding. And then I'll offer, file, and introduce Exhibits 9 and 10 to the record of this proceeding. Now, you just mentioned that these are financial statements for ExxonMobil Pipeline Company, LLC, and ExxonMobil Corporation. Can you briefly explain the relationship first between Denbury Gulf Coast Pipelines and ExxonMobil Corporation?
Denbury Gulf Coast Pipelines is a wholly owned subsidiary of Exxon Mobil Corporation. Financial results reported on a consolidated basis within Exxon Mobil Corporation's financial statement.
So it'd be fair to say that the financial statements for Exxon Mobil Corporation would reflect the current financial position of Denbury Gulf Coast Pipelines.
Yes.
Similarly, can you explain the relationship between the low carbon logistics and Exxon Mobil Pipeline Company?
Low Carbon Logistics is a wholly owned subsidiary of Exxon Mobil Pipeline Company, LLC, which is a Delaware limited liability company. And so the financial results for the entities are reported on a consolidated basis within Exxon Mobil Pipeline Company's financial statements.
So similarly to the question I asked on Denbury, the financial statements for Exxon Mobil Pipeline Company reflect low carbon logistics' current financial position, correct?
Yes.
And is low carbon logistics financially capable of constructing and operating the proposed Charles Lateral?
Yes, it has the full financial backing of Exxon Mobil Pipeline Company, like Charles Lateral.
All right, let's provide a little bit of background on both the Green Pipeline and the Lake Charles Lateral. Let's turn to exhibits 11 and 12 in your binder, if you can identify those for the record.
Yes, Exhibit 11 is a map of the proposed Lake Charles Lateral, and Exhibit 12 is a map of the Green Pipeline system.
And I'll offer file and introduce exhibits 11 and 12 into the record for this hearing. Can you describe the proposed Lake Charles Lateral for the record, please?
Yes, the Lake Charles Lateral will encompass approximately 11.8 miles of up to 12-inch diameter carbon dioxide pipeline, as well as the associated valves and meter stations. The Lake Charles Lateral will connect to the Lake Charles methanol carbon dioxide custody transfer measurement facility at the fence line of the Lake Charles methanol plant, which is to be located in the west bank of the Calcasieu River near the port of Lake Charles. The Lake Charles Lateral will also connect to the existing green pipeline system for transportation of that carbon dioxide to enhance oil recovery projects in Texas. And the Lake Charles Lateral will cross under Interstate 10 in the Houston River, utilizing existing rights-of-way to the extent practicable, and then connect with the existing green pipeline, Louisiana, between Sulphur and DeQuincy.
You just mentioned the Green Pipeline, Louisiana. Can you also describe the Green Pipeline in LA for the record?
Yes, Green Pipeline LA is a 24-inch carbon dioxide pipeline that consists of a pipeline originating in Donaldsonville, Louisiana, and continuing through multiple parishes, approximately 200 miles west, where it terminates at the Louisiana-Texas state line in Calcasieu Parish, Louisiana.
And then what happens once the Green Pipeline LA reaches the Louisiana-Texas state line?
An affiliate, Denbury Green Pipeline Texas, LLC, owns and operates a 24-inch carbon dioxide pipeline known as the Green Pipeline Texas that originates at the terminus of Green Pipeline, Louisiana, at the Texas-Louisiana state line in the Sabine River in Orange County, Texas, and continues approximately 122 miles west across southeast Texas, where it terminates at the West Hastings Field in Brazoria County, Texas.
And just for the record, shifting to the Lake Charles Lateral, has a certificate of public convenience and necessity previously been issued for the Lake Charles Lateral?
Yes.
Okay, can you talk a little bit about that, which I understand regarding the issuance of that certificate?
Yes, Denbury Gulf Coast Pipelines was issued a certificate of public convenience and necessity for enhanced oil recovery for the Lake Charles Lateral that was effective April 17, 2014.
And it's your understanding that was done by PL order number 7203, which was previously admitted as Exhibit 6 to this proceeding, correct?
Yes.
In addition, did Denbury Gulf Coast Pipelines also receive a separate order authorizing it to construct and operate the Lake Charles Lateral?
Yes.
Okay, is that done through PL order number 7204?
Yes.
Okay, and that was also effective April 17, 2014, correct?
Yes.
Can you flip to tab 23 in your binder? And for the record, I apologize about the out of order numbering. I promise I will fill in the interim numbers throughout the course of this proceeding. Okay, and if you're on tab 23, can you identify what that document is?
Yes, it's a copy of pipeline order number 7204.
And I'll offer, file, and introduce Exhibit 23 into the record for this proceeding. And so, just so the record is clear, the present applicants are not seeking to take any action with regard to that prior order, PL order number 7204, which authorized Denbury Gulf Coast Pipelines to construct and operate the Lake Charles lateral, correct?
Yes.
Okay. In fact, as far as you understand, PL order number 7204 has expired.
Yes.
Now, as part of this application, the applicants are seeking to amend and effectively replace that prior certificate of public convenience and necessity, as well as to assign it, correct?
Yes.
Okay. Can you explain why this is being done?
Yes. Since the issuance of the certificate in 2014, Exxon Corporation has acquired Denbury Gulf Coast, and it is now a wholly owned subsidiary of Exxon Corporation. Low Carbon Logistics is also a wholly owned subsidiary of Exxon Pipeline Company. In light of this, Low Carbon Logistics and Denbury Gulf Coast Pipelines seeks to assign and amend the prior certificate of public convenience and necessity into the name of Low Carbon Logistics, which will be the actual entity operating the pipeline in Calcasieu Parish for which the certificate was originally issued.
Can you also explain for the record the additional changes for which the applicants are seeking to amend that prior certificate?
Yes, while the prior certificate was to construct a 16-inch diameter pipeline, Low Carbon Logistics seeks to amend the certificate to reflect a reduced pipe diameter. Low Carbon Logistics now intends to construct and operate approximately 11.8 miles of up to 12-inch diameter carbon dioxide pipeline, as well as associated valves and meter stations. Finally, Low Carbon Logistics seeks to amend the certificate to reflect a slightly different route for the Lake Charles lateral.
And can you, talking first about the reduced diameter, can you just explain why the pipeline diameter has been reduced?
The volume and capacity needed for the Lake Charles lateral was reduced in our calculations, and thus we were able to use a smaller diameter for the pipe size.
And then you also mentioned a route change. Can you explain the reason for the adjustment to the route for the Lake Charles lateral?
Yes, the route is only slightly changed. The pipeline will still primarily be in an established industrial corridor. Since the original grant of the certificate of public convenience and necessity, other infrastructure has been added along the proposed route. And so the route was shifted to accommodate some new infrastructure such as rail spurs. Additionally, the route has been shifted to significantly reduce the impact on existing wetland area.
Okay, and you talked a little bit about the shift, but can you just go into further detail regarding the factors that went into determining the current route for the Lake Charles lateral, which is reflected in Exhibit 11 to this hearing?
Yes, the overall objective is to assess multiple variables and recommend a route with minimal impact. We use satellite imagery as well as field level assessments. We consider the current use of the property, whether it be residential, commercial, agricultural, or industrial. We consider environmental factors. We look at cultural and historical sites, threatened and endangered species, and wetlands. We also have to consider constructability, which means how the actual pipeline will be installed, whether that be through normal excavation, trenchless installations. We need to look at access to right-of-way, as well as the staging of equipment. We also consider existing utilities, whether they be roads, railways, other pipelines, power lines, and then data and cable lines.
Now, when you said normal excavation, when you're describing constructability, is another term for that open cut?
Yes.
And all the factors that you just went through listed, were those all considered in determining the current route that has been included with the present application and for which the applicants seek to amend the existing certificate to reflect?
Yes.
All right. You discussed that a certificate had previously been issued to Denbury Gulf Coast Pipelines. Had Denbury Gulf Coast Pipelines actually required any voluntary servitudes for the pipeline?
Yes.
Is it your understanding that some of those servitude agreements have at least expired as of the current date?
Yes.
Okay. Presently, has Low Carbon Logistics begun to reach out to landowners along the current route?
Yes.
And at the time of this hearing, has Low Carbon Logistics attempted to make contact with all of the landowners over whose property the pipeline will traverse?
Yes.
Once constructed, what is the anticipated initial volume of carbon dioxide that will be transported through the proposed Lake Charles lateral?
It is anticipated that initial volume of carbon dioxide to be transported to the proposed Lake Charles lateral will amount to approximately 1.1 MPa, with potential future flow rates above the 4 MPa.
When you said I think you said MTA, did you mean 1.1 MMT per annum?
Yes.
Okay. And just for completeness purposes, can you flip to tab 13 in your binder and identify that document for the record?
That's Form PL-4 that was attached to the application.
And I'll offer, file, and introduce Exhibit 13 into the record for this proceeding. Let's now talk, we talked about how the CO2 will be going to EOR projects in Texas. Let's talk about those projects. Will the Lake Charles lateral facilitate the transportation of carbon dioxide to the green pipeline system for delivery to enhanced oil recovery projects?
Yes.
Okay, and that includes 2 enhanced oil recovery projects in Texas, correct?
Yes.
And where are those enhanced oil recovery projects in Texas located?
The enhanced oil recovery projects in Texas are in the Oyster Bayou unit and the West Hastings unit.
And as the onshore pipelines projects manager, are you familiar with those enhanced oil recovery projects?
Yes.
Can you further describe both of those projects for the record?
Enhanced oil recovery for the Oyster Bayou unit was originally approved by the Railroad Commission of Texas on June 22nd, 2010. The Oyster Bayou unit is located in Chambers County, Texas, while the enhanced oil recovery project for the West Hastings units was originally approved by the Railroad Commission of Texas on November 25th, 1985. The West Hastings unit is located in Brazoria and Galveston County, Texas.
And I'm going to have you look and identify a whole tranche of documents. If you can look through tabs 14 through 19 of your binder and just identify each of those documents for the record in this proceeding.
Exhibit 14 is a copy of the final order whereby the Railroad Commission of Texas approved the enhanced recovery project for the Oyster Bayou unit, and oil and gas docket number 03-026-5447. Exhibit 15 is a copy of the final order whereby the Railroad Commission of Texas approved the enhanced recovery project for the West Hastings unit, and oil and gas docket number 3-85-302. Exhibit 16 is a copy of the well permit for Oyster Bayou unit, well number 503. Also has a designation of API number 420-710-2313, which is a carbon dioxide injection well in the Oyster Bayou unit. It's approved by the Railroad Commission of Texas. Exhibit 17 is a copy of the well permit for West Hastings unit well number 1190, also designated as API number 420-393-3081, which is a carbon dioxide injection well in the West Hastings unit, was approved by the Railroad Commission of Texas. Exhibit 18 is a list of active carbon dioxide injection wells in the Oyster Bayou unit. And finally, Exhibit 19 is a list of active carbon dioxide injection wells in the West Hastings unit.
And I'll offer and file and introduce exhibits 14 through 19 for the record for this docket. And we talked, there's only one well permit for each of the units, but for the record, each of the wells listed in exhibit 18, do their well permits look similar to the one found in exhibit 16 and have likewise been approved by the Railroad Commission of Texas?
Yes.
And similarly, for each of the wells listed in exhibit 19, do their well permits look similar to the one found in exhibit 17 and have likewise been approved by the Railroad Commission of Texas?
Yes.
Were both the Oyster Bayou unit and the West Hastings unit enhanced recovery projects approved by the Railroad Commission of Texas?
Yes.
Do the final orders from the Railroad Commission of Texas approving the Oyster Bayou unit and the LCM unit still ongoing?
Yes.
And then finally, is the proposed Lake Charles lateral reasonably necessary to allow for the reliable transportation of carbon dioxide from the Lake Charles methanol plant through the Green Line for delivery to the enhanced oil recovery projects, including those for the Oyster Bay unit and the West Case section?
Yes.
And in fact, are there any existing pipelines that could actually transport the carbon dioxide from the Lake Charles methanol plant to the Green Line?
No.
Let's turn now to some of the public benefits of being able to capture the carbon dioxide from the Lake Charles methanol plant and then transport that carbon dioxide through the proposed Lake Charles lateral to the Green Line for enhanced oil recovery. Can you just go through some of the public benefits of being able to capture that CO2 and transport it from the Lake Charles methanol plant through the Lake Charles lateral and to the Green Pipeline system for enhanced oil recovery?
Yes, those would include the improvement of the available transportation facilities for the movement of captured carbon dioxide to enhance oil recovery projects, commensurate with the general health, safety, welfare, and prosperity of the state of Louisiana. It supports the broader goals of reducing industrial emissions, helps to facilitate additional markets for the products to be produced at the Lake Charles methanol plant. It allows the Lake Charles methanol plant to produce lower carbon products. Facilitates more markets for Louisiana products, and allows the Lake Charles methanol plant to expand, increase production, and increase related economic benefits without increasing its carbon dioxide emissions. It also advances regional decarbonization and creates and retains jobs for Louisiana workers. For example, the Lake Charles lateral alone will result in approximately 250 Louisiana construction jobs at peak, and it has economic benefits to state and local communities and governments. The Lake Charles lateral will also result in approximately $150,000 in property tax.
And so you kind of briefly talked about this, but in addition to those direct benefits from the pipeline itself, the construction of the pipeline and the proposed facilities will also support the Lake Charles methanol plant, correct?
Yes.
And are you actually familiar with the Lake Charles methanol project?
Yes.
Can you tell us a little bit about that?
The Lake Charles methanol project is a multi-billion-dollar investment in Louisiana to produce methanol and natural gas. The plant will purchase approximately $500 million a year of Louisiana natural gas and manufacture high-value methanol. The project will use abundant, clean Louisiana natural gas and create substantial economic benefits for the state and the local community beginning in 2026. The construction of the Lake Charles methanol plant is expected to commence in 2026 and will create over 11,000 direct construction jobs, over $1.5 billion in labor income and wages, and $160 million per year in local tax revenues. Once operational, the project will maintain an operational staff of over 200. In total, it will create an estimated 439 new direct and indirect jobs per year and generate over $400 million in local labor income per year.
And just so the record is clear, I think you said it will generate over $40 million in local labor income per year. Is that correct?
Yes.
Now, talk about a lot of things. So fair to say that the Lake Charles lateral will have a multitude of both direct and indirect benefits within the state.
Yes.
Let's shift gears a little to the public interest served by enhanced oil recovery, just in general. How can enhanced oil recovery, the carbon dioxide, actually increase the production within a field?
The U.S. Department of Energy estimates that only about 20 to 40% of original oil in place is produced with primary and secondary recovery methods. Carbon dioxide enhanced oil recovery can extract another 5 to 15% of the original oil in place.
And just for the record, can you briefly explain the general process for enhanced oil recovery in these fields?
Yes, carbon dioxide is injected into mature reservoirs where it mixes with the remaining oil and also increases reservoir pressure, enabling more oil to be produced. Some of the carbon dioxide is trapped and is incidentally stored in this process, and some of the carbon dioxide is produced with the oil, then recaptured and recycled for reinjection.
And what carbon dioxide does the green pipeline system currently use for enhanced oil recovery operations?
Primarily Jackson Dome.
And with the industrial carbon dioxide added to the green pipeline system for both this and other facilities, be replacing Jackson Dome's naturally occurring carbon dioxide.
Yes.
And what are some of the benefits of adding this industrial, or sometimes referred to as anthropogenic, carbon dioxide to the system as opposed to using the naturally occurring carbon dioxide from Jackson Dome?
Industrial carbon dioxide would otherwise be emitted into the atmosphere, whereas the naturally occurring carbon dioxide would not be. It is contained in the Jackson Dome. So by using industrial carbon dioxide, we reduce overall emissions through the enhanced oil recovery process. Naturally occurring carbon dioxide is also finite.
So based on everything you said, is it fair to say that by being able to transport and use industrial carbon dioxide on the green pipeline system, we can actually extend the life of these and possibly more fields over time?
Yes.
Now let's shift gears a little bit and look at the willingness and ability to perform the services contemplated to conform to the law. Is low carbon logistics able and willing to properly do the acts and perform the services proposed in the application and to conform to all applicable provisions of Title 30 of the Louisiana Revised Statutes?
Yes. As a wholly owned subsidiary of Exxon Pipeline Company, Low Carbon Logistics will be comprised of experienced staff from both Exxon Pipeline Company and Denbury. Exxon Pipeline Company is an experienced operator of pipelines in multiple states. Specifically in Louisiana, Exxon Pipeline Company has approximately 100 employees involved with pipeline operations. Exxon Pipeline Company currently is operating approximately 325 miles of carbon dioxide pipeline in Louisiana. Exxon Pipeline Company also is operating hundreds of miles of pipeline storage projects and fuel and oil terminals throughout Louisiana. Low Carbon Logistics is also financially capable of complying with the applicable pipeline laws and regulations. As previously mentioned, it has the full backing and support of Exxon.
I think you mentioned it's currently operating approximately 325 miles of CO2 pipeline in Louisiana. Does some of that pipeline include both the Green Pipeline in LA and then what's sometimes referred to as the NEJD, Northeast Jackson Dome line?
Yes.
Now, as part of that expertise, is ExxonMobil able and willing to conform to the applicable laws and regulations related to the construction, design, operation, and safe operation of pipeline and related facilities?
Yes, we are intimately familiar with the applicable laws and regulations.
And you kind of went through a little bit of ExxonMobil's operations, but how long has ExxonMobil actually been in the pipeline business?
Over 100 years.
Does ExxonMobil have numerous personnel whose job it is to ensure compliance with those applicable laws and regulations?
Yes.
Getting into specifics, do you have personnel intimately familiar with CO2 pipelines?
Yes. In fact, we believe we have the most knowledgeable in the industry. Through the acquisition of Denbury, which is the single largest provider of carbon dioxide transportation services, we acquired the most knowledgeable and experienced personnel in the industry. We inherited 200 to 300 employees across the country that routinely operate carbon dioxide pipelines. And we believe that no one in the industry comes close to our experience and knowledge operating carbon dioxide pipelines.
Relatedly, do you have personnel specifically dedicated to the health, safety, and environment in the carbon dioxide context?
Yes, many.
And does that knowledge and experience of your personnel inform decisions relating to the electrolyte?
Yes.
Looking at more specifics, will the materials used for the piping and related facilities be compatible with the carbon dioxide being transported?
Yes.
And will you also be monitoring the piping and related facilities to prevent corrosion?
Yes.
If you can turn to Exhibit 24 in your binder, and identify that document for the record.
Yes. Exhibit 24 is a document outlining how ExxonMobil leads the development of enhanced safety practices and standards for its carbon dioxide pipelines.
I'll offer file and introduce Exhibit 24 into the record for this hearing. Can you just tell us about the safety of carbon dioxide pipelines in general?
Yes, carbon dioxide pipelines have safely operated in the United States for more than 50 years. CO2 lines have a history of extremely low incident rates per mile when compared to crude oil and refined products pipelines, which is reflected in the chart at the bottom left of Exhibit 24.
Okay, you just talked about the chart at the bottom left of Exhibit 24. I also see we're talking about the first page of Exhibit 24. I also see a chart on the right side of Exhibit 24. Can you just identify for the record what that chart is showing?
Yes, there's only been one injury associated with the carbon dioxide pipeline, and that was back in 2007. And it notes that the injury was associated with an excavation of a carbon dioxide pipeline. It was not associated with operations, a leak, or a spill.
And just for the record, that statistic, that doesn't come from Exxon. Where does that statistic actually come from?
It's from the U.S. Department of Transportation's Pipeline and Hazardous Materials Safety Administration. It's the acronym things that.
So is it fair to say that contrary to suggestions otherwise, carbon dioxide pipelines are actually in fact extremely safe?
Yes. And as a general matter, they're very safe. Additionally, our knowledge and experience enables us to further ensure safe operations.
Can you just briefly talk about what helps contribute to the safety of these pipelines?
There are hundreds of safety requirements that govern carbon dioxide pipeline construction, inspection, maintenance, monitoring, and incident response. Federal law requires integrity management programs for pipelines in high consequence areas, such as populated areas. We also conduct significant monitoring operations. For instance, we monitor pipeline operations 24/7. Our state-of-the-art operations control center, where we can shut down pipelines with the press of a button. We also have on-site technicians who regularly inspect the facilities, and we have specifically trained pilots that conduct aerial patrols on the pipeline route.
In addition to following all applicable laws and regulations, do you also follow and implement all American Petroleum Institute, sometimes known as API, recommended practices?
Yes.
Can you just, for the record, briefly talk about your emergency preparedness?
Yes, we have developed an industry-leading safety culture, an integrity management program designed to prevent incidents from happening, to prepare for the rare possibility of an incident. We regularly meet and train with emergency response officials and first responders. We create, maintain, implement, and drill emergency response plans that are specific to every county and area. These are hyper-local plans that take into consideration local nuances that may impact emergency response.
And you do that same, those same activities that you just described in practices for this Lake Charles lateral?
Yes, we already have familiarity with Calcasieu Parish, and we have been doing training for first responders for the parish for years. In fact, just next month, we are hosting 2 trainings in Calcasieu Parish in connection with the Green Pipeline.
And Exxon Pipeline Company has actually been recognized for its attention to safety, isn't that correct?
Yes, we earned the American Petroleum Institute's top safety award 3 years in a row, which frankly is quite impressive.
And again, all of the foregoing knowledge, experience, practices that you described, those will all be applied in connection with the Lake Charles lateral, correct?
Yes.
So, a lot of discussion, just in conclusion, to round it all out, is Low Carbon Logistics able and willing to properly do the acts and perform the services proposed in the application and to conform to all applicable provisions of Title 30 of the Louisiana Revised Statutes and all applicable regulations?
Yes.
Let's turn to the interested parties list and notice. Have you been informed regarding the process established used to notify interested parties of this hearing on the pending application?
Yes.
If you could flip to Exhibit 20 for me, and identify that document for the record.
Exhibit 20 is the list of interested parties.
I'll offer file and introduce Exhibit 20. Can you just briefly describe for the record what your understanding of the purpose of that list is?
Yes, it is to identify all interested parties along the route of the Lake Charles lateral, as the term interested parties is defined in the applicable regulations.
And the list shown in Exhibit 20, that includes all landowners along the proposed center line of the Lake Charles lateral, correct?
Yes.
Okay, and is the green line the only pipeline that the Lake Charles lateral would actually connect with?
Correct.
Let's turn to tab, sorry, if I didn't for the record, I'll offer final issues Exhibit 20. Let's turn to tab 21. Can you identify that document for the record?
Yes, Exhibit 21 is my affidavit showing that the research was done to determine the interested parties.
And I'll offer final issues Exhibit 21 into the record for this proceeding. Was a reasonable search made of public conveyance records by land professionals to identify interested parties as that term is defined in the applicable regulations?
Yes.
And that reasonable search was made of public conveyance records to obtain the names and addresses of all interested parties whose properties are to be traversed by the proposed Lake Charles lateral?
Correct.
And does that include a reasonable search of the ad valorem tax records of Calcasieu Parish?
Yes.
And that also included a reasonable search of the clerk of court records for Calcasieu Parish, correct?
Yes.
And did Low Carbon Logistics mail legal notice of the hearing and a copy of the application to all the interested parties listed in Exhibit 20?
Yes.
And how was that mailing done? Was it first class mail?
Yes.
And on what date was the legal notice of the hearing and a copy of the application mailed to the interested parties listed in Exhibit 20?
January 21st, 2026.
Okay, and for the record, when did Low Carbon Logistics actually receive the legal notice of this hearing from the Department of Conservation and Recreation?
January 20th, 2026.
So the first class mailings on January 21st, 2026 occurred within 2 working days of receipt of that legal notice from the department, correct?
Yes.
And the final exhibit that I'll admit is tab 22, which is the affidavit of T.J. Grimsall confirming the mailing of the legal notice and the application to be first class mailed to the interested parties listed in Exhibit 20 to this hearing. Mr. Rock, I'm almost done with your direct. I want to turn to responses and public comments. As part of your role, have you reviewed some of the public comments received to date in this document?
Yes.
Okay, specifically, did you review a public comment regarding the proximity of a residential neighborhood on the eastern boundary of the city of Sulphur to the current route for the Lake Charles lateral?
Yes.
Okay, did you specifically review that area as part of devising the current route for the Lake Charles lateral?
Yes.
Okay, and what did your review show?
At that location, there are 5 existing petrochemical and natural gas liquids pipelines in the area, which are adjacent to the residential neighborhood, including 2 that have pipeline markers showing that the lines are located within the backyard fence line of the residential property.
And how does that actually compare to the current route for the Lake Charles lateral?
The current proposed route would be farthest from the residential homes, and the pipeline would be buried at over 75 feet deep by way of horizontal directional drilling.
You just referenced the 75-foot depth. In your experience, how does that compare to the typical depth of cover for new pipelines?
Depth of cover is addressed in the applicable pipeline regs, but typically, a pipeline would be installed by normal excavation with 36 to 48 inches of covering. Using a horizontal directional drilling method allows us to bury the pipeline at a much greater depth.
And shifting to a different public comment, did you also review a formal objection from an entity in Kronos, Louisiana, Inc.?
Yes.
Okay, can you inform the director what happened after you were notified that Kronos, Louisiana, Inc. was objecting to this application?
We met at the Kronos facility in Lake Charles, Louisiana on February 17th, 2026. And during that meeting, it became clear that they did not appreciate the depth of the horizontal directional drilling that would be done for this pipeline. And as a result of that meeting, we agreed to work collaboratively on a route across the property.
And in fact, did Kronos, Louisiana actually tell you anything regarding the objection that they had previously filed?
Yes, Derek Turner with Kronos, Louisiana, the plant manager. He was the individual who signed the formal objection filed in this docket. He told me that they plan to retract the formal objection, and then he told me I could inform you today that they intend to retract their objections to this application.
Thank you, Mr. Rockaby. That concludes my direct examination.
I have a few questions before we get to public comments. I'm particularly interested in a lot of it, but the green line. Is that line an intrastate line now by function, or is it still an interstate line? You mentioned that the start of it is in Donaldsonville and it ends at the state line. And that is the entirety of the green line operated by Denbury Gulf Coast? Or does a segment going into Mississippi, is that also part of the pipeline operated by Denbury Gulf Coast? I'm curious about that. I know it's not necessarily a big deal with this hearing, but I was interested in that.
All those pipelines you described are all interconnected.
Sure.
There's a carrier of carbon dioxide. The interstate, the laterals connecting to it are within Louisiana are intrastate. I think we talked about it in previous hearings. But the actual green line itself, it would be registered. I'm not sure how that line is registered in your system.
Okay.
We can check and follow up.
Yeah, I know some names have changed on the lines over the years, and of course this has to do with our safety program, whether or not the line will fall under our jurisdiction or not. If it's truly, and it depends on operator names and all that kind of stuff. So, that's a sidebar to this application that I wanted to get to. Will the CO2 you're proposing to, or that plant will capture and that you will take, will that replace CO2 out of Jacksonville, or will that be CO2 going into the line and it will replace some of the CO2 coming out of Jacksonville?
Yes, it would replace it.
What's the status of the methanol plant? I know you said that they were planning to commence construction in 2026. Do they have all permits in place for construction?
No, I understand some permits are still outstanding.
Do you know the status of those? Do you know which agencies may be reviewing those permits and where they're at on that?
We can follow up with a supplement on that, but I know they've received their air permit, they've received their water permit, and this is one of the permissions that they also need, but we know they've received air and water.
Okay, do you know of any other permits that the plant needs to be constructed?
We will follow up, and I believe they will need a Corps of Engineers.
Corps of Engineers.
But I will check, I will verify that and get back with the commission.
Okay, appreciate that. And they have all funding in place for that methanol plant?
They have some funding, but for final FID, they need their permits in place, including this certificate.
Yes, I did, what happens if, this pipeline cannot be built for whatever reason, regardless of the certificate? Does that plant still get constructed, or is it relying on this pipeline? Will that plant still be able to operate, be constructed and operate without the CO2 line?
We believe it needs this certificate to get FID, but we can follow up with an affidavit from them.
Yeah, I know I have a lot of questions about the plant, and we don't necessarily have those folks maybe here in the room unless they are here in the room. Okay, I don't see that anyone's. Yeah, if you could come up, if you have some of the answers for the questions I'm asking, I'd be happy to, if you would, state your name for the record.
And Mr. Commissioner, if he doesn't have all the answers you need today, we will follow up with them.
Thank you. I would you please state your name and position for the record.
My name is Hunter Johnston. I'm counsel to Lake Charles Methanol. I'm a resident of New Orleans, Louisiana.
Okay, thank you. And so, are you familiar with the status of the permits for that plant?
As counsel just mentioned, the major permits are the air and the water permits, and those have been secured from the state.
Is there a Corps of Engineer permit needed for the plant?
There's a Corps permit. I'd have to check on the exact status of that.
Okay. And again, so my question of if this pipeline cannot be constructed, will the plant move forward with construction?
So this project will be a project finance. And we have offtake contracts with major counterparties that are going to buy methanol because of the low carbon attributes of the project, of this methanol. As was mentioned, this methanol project is going to take Louisiana natural gas and convert it to high value methanol. Methanol with the low carbon attribute is valuable in world commerce, and it will displace methanol that's produced by mostly China coal. So coal feedstocks from China. So basically we're using Louisiana resources to produce methanol and export it around the country. So when you ask, is this certificate necessary for financial close, it's absolutely necessary for the attributes that our off-takers are purchasing methanol for. It's a great advantage that Louisiana has to have the availability of carbon sequestration through enhanced oil recovery, and also Haynesville gas, which has low carbon attributes to it. So that's really the value proposition for the project is based on this.
All right, thank you for that. Would anybody like to come up and make a comment? Well, I should have taken roll before, so we can go in order, but you're closest to the desk, so I'll ask, sir, if you would get up so we can, this gentleman come here and make a comment. I'll do my best to try to, take votes in some kind of order. Please state your name for the record.
My name is Les Solomon.
Is the mic turned on?
I turned it
Where's the button?
There we go. So my name is Les Farnham, State Representative for District 33, which is the salt area. So this pipeline will be coming right through, literally 25 feet from the city limits of Salt. There's lots of residents that live in that area. I think the problem that I have, the biggest problem that I have with it is proximity to those residents. Children be playing in those backyards. I know most pipelines are trouble-free, but then there's always a chance. The biggest problem that I have is the process of this application. So I've talked to the generator, I've talked to the transporter on numerous times. The generator has told me that at the end of the day, this needs to be sequestered carbon. That they will allow EOR for some period of time until there's a chance to sequester. But upon a Class 6 well being deposited on the pipeline somewhere, it's going to be sequestered at the end of the day. And the legislature went to a lot of trouble to put some guidelines in effect that you either have to, the only way that you can get a certificate, according to Works 1107, is to, you got to use the expropriation process in order to take land that is, I guess, divided a lot where you can't figure out who owns it, or they exhibit that they're going to be a common carrier.
Mm-hmm.
I don't think either one of those apply to this. It's the legislative intent was very clear, I believe, of where we wanted to go with pipelines when it relates to CO2. And I don't believe this fits into the mold that we tried to create last year.
Mm-hmm.
And I know there's more and more and more of it coming. So if you actually granted a certificate based on EOR, knowing that it's going to go to CCS, two different worlds. The guidelines are different in both cases, and I think we're circumventing our process when we allow a short-term use for a different long-term purpose.
In your conversations with Lake Charles Methanol, I'm interested in the comment that the CO2 can only go to EOR for a certain amount of time. Did they give you a timeline as to when they would need that CO2 to be sequestered? And I'll ask that question of the Exxon representation here as well. Is there a timeline that has been conveyed to you that, 6 months from now, a year from now, this is gonna need to be sequestered? It won't be, it won't be available for EOR anymore because of whatever contracts they have in place.
And I do not know, I don't believe Mr. Lockerbie
No, I do
knows
not.
either. But Commissioner, I mean, obviously, if they want to sequester CO2, if we would need to make a separate filing for authority for that, and which is not what we're doing here today.
I understand.
I can answer that question.
Yeah, thank you. Thank you. I do have a representative here.
So, enhanced oil recovery does sequester CO2, and that's why it meets our commercial objectives. So it's just, they're both non-EOR and EOR sequesters CO2. So our contracts stipulate that it can be either EOR or non-EOR sequestration, but Exxon offers no non-EOR sequestration proposition at the moment. So the whole reason we're doing business with Exxon is because of the certificate that's available, so that we can give assurance to our investors that we can build this pipeline so that we can offer low methanol product to our offtake customers.
Thank you for that.
I think there's a lot of truth to the fact that EOR, CO2 is temporarily sequestered. And then there's a difference between permanent sequestration and temporary sequestration. They put it into a well and extract it, it comes and goes back and forth, and permanent is permanent. So two different purposes, and it was communicated to me very clearly that as soon as the Class 6 well comes into operation, that's where this CO2 will be demanded to go.
You have any comments?
I just think we're putting the cart before the horse here, because this is a situation where the company has not reached FID, and it's been communicated to me very clearly that they won't even take action on FID until they have a pipeline. So it's a chicken and egg scenario, which comes first. So we're rushing to a situation where we approve a certificate to take people's property. That doesn't fit the legislature's intent in order to get to a company to reach an FID. And this can't be our primary focus. Is how do we get this project? I thought I was in an LED meeting a minute ago. Sounded more like economic development pitch than a pipeline pitch. It's troubling to me to see what we're trying to do here is to get a pipeline in place where we don't have a generator for it, but the generator won't come, and the pipeline's there. So I think they need to lock hands, get together, and figure out what's going to happen before we go to all this trouble to go start figuring out how to expropriate property. And it's very clear in the statute that there's only two reasons you can take the property. One is when it's convoluted in court where nobody knows who owns it, and the other one is a common carrier application. And I think at a minimum, they need to be applying for a common carrier application instead of an EOR application. Thank y'all for y'all's time.
Thank you. Your hand was up first, miss. Beat you to the punch, sir. I'll get you next.
Thank you. My name is Caroline.
Well, if you want to defer, I promise I'll get to everybody. I know I called you. If you want to come up, you can come up. I did call on this lady here. I'm sorry.
Go ahead. Yeah.
Please state your name for the record.
Commissioner, thank you. My name is Desiree Moore. I am the Executive Director of Industry Makes. Industry Makes is a 501c4 that advocates for responsible industrial development in Louisiana. modification, not the application, the modification of a current certificate, that was granted originally to Denbury in 2014 to support the processes of the proposed Lake Charles methanol project. Since that original certificate was issued, construction of the Lake Charles methanol plant was put on hold. And thus, the construction of the Lake Charles lateral pipeline was also put on hold. Since 2014, Denbury has been acquired by Exxon, which rules and regs demand that we modify the certificate to represent the current owner and who would be responsible for the processes. Today, Lake Charles Methanol has plans to move forward with its multi-billion-dollar investment. In light of that, there are also plans to move this Lake Charles lateral forward as well to support those processes. To comply with Louisiana law and state regulations for the potential pipeline project, Low Carbon Logistics is seeking to amend the existing EOR certificate from 2014 for the Lake Charles lateral pipeline to reflect that Low Carbon Logistics will be the entity constructing and operating the pipeline and to reflect the minor adjustment to the pipeline route. As stated earlier, the adjustments to the pipeline is due to the fact that the original route is 12 years old and new surface conditions such as new infrastructure have been placed and drainage has been discovered. So those adjustments reflect those changes in the infrastructure. In summary, the modification is demanded by Louisiana law. The pipeline will be installed in an existing utility corridor with more than 20 pipelines and high voltage power lines already in existence. In the area near the I-10 crossing, the pipeline will be installed more than 70 feet deep by horizontal directional drilling, far below the roads, the structures, and the existing petrochemical and natural gas liquid pipelines that are already in that area. And lastly, PHMSA data shows that pipelines have a better safety record than any other form of transportation, more than truck, rail, or marine transport. I respectfully request that you support the certificate for modification. Thank you.
Thank you. Sir, you may come up. Please state your name for the record.
John Lewis, representing myself. First, I'd like to acknowledge the fact that inside the application that it did state that the current certificate was in good standing, force, but a lot's changed over 12 years, right? To go back to the EOR versus CCF discussion, if you look at the environmental information assessment as part of the RPN-1 injection well that was recently heard in Ascension Parish, the applicant specifically stated in their alternative analysis that it was not productive for that process of EOR because they are not the same. The applicant said that. So there's two very distinct processes for EOR and CCS. It's in the environmental information assessment part of that application that was just heard by this agency.
Sorry, who was the applicant for that? It was
River Parish Irrigation Project. There's a total of 7 injection wells planned. They just recently heard the first one in Ascension Parish. I believe that was last month. Does that answer your questions?
Yeah, it does. Proceed, please. Thank you.
So what we're talking about here is public convenience and necessity, right? Public good, public need. Last week, EPA ruled in relation to the endangerment finding. I'm sure everybody's aware that they were basically rescinding and revoking the endangerment finding of 2009. There's another subsequent ruling pending for mid-2026 of this year in relation to the greenhouse gas reporting program. It may not be a total revocation, but it's a significant revision as far as what industry and what is reportable under the greenhouse gas reporting program. That also should be taken into consideration for the this application. Once again, who is it good for? What we're asking is the citizens of Louisiana, in particular, in Calcasieu, to potentially lose land through expropriation, sorry, big word. But it's going to Texas, right? So we're moving something, taking land here to move something to Texas. So public good, public need for who? That would be my question up front. I'd ask if the applicant has reviewed, and kind of touched on the applicant reviewing their initial IT submission as part of the certificate. 12 years, a lot of change, a lot of development, a lot of different things as far as the social impact could be relevant in determining if the certificate should be either amended and or reissued moving forward. Lastly, and this is just a big one for me, given my background. I keep hearing about lowering emissions. It was stated here in testimony today. And I'd ask, is that lowering emissions of greenhouse gases, or are we lowering emissions totally to include HAPs and TAPs, your hazardous air pollutants, your toxic air pollutants? There's a scheduled hearing in Raglan on March 5th for a Clean Air Act permit that I'm going to. The reason I say that is that particular company is having to apply for a major source air permit as opposed to a minor source air permit, even though they're doing the same thing, but the change is to support carbon dioxide removal, drying, transportation. That's why they're having to move from a minor to a major source specifically, and that's with the Gillis treatment facility. I'd love to delve into more of the clean air versus not clean air, but that's not what this hearing is for. It's for a certificate of public necessity. But I do think that all of that, when you look at the total picture of how things are being put together, those comments are relevant. So I thank you for your time, sir.
Thank you. Miss?
Was it you? I'd also like to make a comment.
Go first.
Okay.
I'm calling this lady here, sorry.
No, you're good.
You gotta get your hands up quick, or we can even form a line, it doesn't really matter to me. I know we have a lot of folks here to talk, and we're gonna make sure everyone gets their chance. Please state your name for the record.
Hi, good morning. My name is Maria Harmon. I live in Baton Rouge, Louisiana, but I have family property in Mossville, which is between Salford and Westlake. The reason I'm sitting here is really regarding this project for modification of certificate is in regards to the potential of land being taken from homeowners and landowners. People in that area have been able to maintain their land for generations. I feel compelled to just share this perspective as just being a good neighbor in that area. The pipeline doesn't affect where my family's property is, but again, I can't stay quiet and not be a good neighbor and use my voice. The idea of eminent domain being an aspect of this project is extremely harmful. The idea of families being further exposed to pollution is extremely harmful. Pipelines, though they may be deemed as safe, there's always a chance of leakage. There are plenty of articles that account for extreme happenings that are extremely unfortunate to those impacted of essentially a carbon bomb going up. We can't afford to have our communities exposed to that type of experience. The fact that eminent domain can even be considered in an aspect like this to advance a project for a private corporation, I just find to be completely unethical. And we have to rely on our public entities like you guys to really speak up for our communities and think about us in the aspect of all of this. Thank you.
Thank you. Thank you. Please state your name for the record.
My name is Michael Samuka. Since you had some questions about the associated facility that Charles Methanol, I just wanted to address the status of that facility briefly and then touch on some of the other aspects of the certificate. So this company, like Charles Methanol, they have a long track record of mismanagement and delays. Lake Charles Methanol 1 was originally proposed in 2016 as a pet coke to methanol facility. There were 7 years of permit delays, requested extensions, and even though they did receive a $2 billion loan from the U.S. Department of Energy, the project failed to ever move forward. So after 7 years, Lake Charles Methanol redesigned the facility, changing it down to the most fundamental aspect, which is the feedstock. So now it will be using conventional, natural gas to methanol, to create methanol. Thus far, the Lake Charles Port Authority has already spent $2.3 million on various construction projects to help LCM2. LCM2 has already received a $5 million grant from the Louisiana Economic Development Agency. Once the permitting process goes into effect and construction begins, LCM2 will owe the Lake Charles Port a $3.8 million payment up front. They have also continued to seek billions of dollars in financial assistance from the government, with its chief executive quoted in the press saying a $3 billion guaranteed loan from the U.S. Department of Energy will be necessary for the project to move forward. They have also stated in meetings with the Lake Charles Port Authority that they would be relying previously on the 45V tax credits for hydrogen, which because of actions from President Trump will no longer be available, and so they will have to come up with a new financial plan for the facility that relies on the 45Q tax credits. Finally, in November 2025, the Sulphur City Council in Calcasieu Parish unanimously rejected 2 ordinances for the LCM2 facility and CO2 pipeline. These ordinances would have allowed the city to enter into lease and purchase agreements with LCM2, and my understanding is that decision was made in response to some of this economic mismanagement. Again, this was a unanimous denial from the Sulphur City Council. Regarding the request to amend and reassign the Certificate of Public Necessity and Convenience, Louisiana Revised Statute 45162 says that certificates automatically terminate if the holder fails to begin construction or operation within a reasonable timeline. If no specific timeline is established, 12 years is not a reasonable timeline. Louisiana Revised Statute 45166 for Louisiana Intrastate Pipeline states that no certificate or permit shall be sold, leased, or transferred, nor shall any such certificate or permit be used by any other than the person, firm, or corporation to whom it was originally granted, unless and until it can be shown that the owner thereof shall have for a period of 6 consecutive months immediately prior to the transfer or use thereof substantially operated all rights under said certificate or permit. So given that there's been a 12-year period that's passed since the original certificate was issued without the pipeline ever coming into operation, given that there's been a change in ownership of the certificate holder with Exxon coming to acquire these companies and now transferred from Denbury to Low Carbon Logistics since the original certificate was issued, given that the original plan for this pipeline was to support the Lake Charles Methanol 1 facility and that facility has been completely redesigned and reintroduced, and given that there is now a request to significantly modify the pipeline, changing its route and its size, the original certificate must be considered to have been terminated, and the company should begin a new process of application for a certificate of public necessity and convenience with legitimate opportunities for the public to provide input. I think it's very, very difficult for folks in Calcasieu Parish to make it to Baton Rouge at 9 a.m. on Monday. So, and then finally, I know I'm going a little long with this, little wrap it up. Regarding safety issues, since those were addressed, we're all aware, I think, of the Denbury pipeline that ruptured in Yazoo County, Mississippi. 50 residents were hospitalized. In April 2024, the Exxon Denbury CO2 line ruptured near Sulphur. This led to a shelter-in-place order. Local residents report receiving no emergency notification and not becoming aware of the leak until they went on Facebook and saw people posting about it. No alerts, no alarms. In February of 2025, PHMSA, the Pipeline Hazardous Materials and Safety Administration, proposed a $2.4 million fine against Exxon Denbury and a contractor after they menaced federal employees, intimidating and threatening those who were sent to conduct safety inspections on the CO2 pipeline. This $2.4 million proposed fine is the second largest penalty ever proposed in the history of PHMSA's operation as an agency. Thank you.
Thank you. Please state your name for the record.
My name is Ashley Stelly. I've never done this before, so bear with me. Good morning, elected officials. My name is Ashley Stelly, and I'm a Calcasieu Parish resident. I'm also a mother to 4 kids, CFO of my fiance's veteran-owned business, Advanced Auto Repair LLC, and junior level natural resource conservation management student at McNeese State University. I'm also the daughter to a pipeliner and engaged to the supervisor of the machinists for an oil and gas plant which produces some of the burn-off waste like carbon. I come to you to make my comments about the transfer of the existing certificates and the pipeline known as the Green Pipeline and LA locations. Two of my kids attend Gillis Elementary, which is at 805 Topsy Road and less than 1,200 feet from the pipeline. It's also about 1,000 feet from a creek or bayou. This line goes underneath the homes across the street, which have hundreds of renters. And my concerns for that is the regulations and standards and the safety, which has already been demonstrated. There have already been leaks in the pipeline near the Gillis Elementary School that was touted as natural gas, not the carbon pipeline itself. This was September 3rd, 2024. A large gas leak happened near the school and CPSB did not send the kids home nor inform the parents until days later. Within a week, emergency services responded to a CM2 alarm that was claimed to be malfunctioning detector within the school itself. Parents were not notified about this either. Despite my requests, I received no follow-ups or reports related to those two incidents from Calcasieu Parish School Board. My concern is that the porous nature of the carbon steel pipeline itself and the degradation of the internal liners over time. When the porous material allows moisture inside from the wear and tear over the years, it creates something called carbonic acid. Carbonic acid heats carbon steel. It's highly corrosive to carbon, steel, and iron. When this happens, it can cause not only minor leaks, but also major unzipping, which creates what's called a kill zone of 1,500 feet, where anything in that area is immediately neutralized and no longer with life. A failure of this degree can happen right near my kids' school, right near their playground, with no warning, no ability to evacuate, and the school board's already shown that they do not keep their systems up to date in this area, and they do not notify parents. Gillis Elementary and that surrounding area is a low socioeconomical area. It is in the Moss Bluff area, and Moss Bluff has their elementary school divided into two places, Moss Bluff Elementary and Gillis Elementary. Gillis Elementary houses all the rural and low-income kids. I live on the line for that. I'm fortunate enough to be able to out-of-zone my kids for the next school year because I don't feel safe and comfortable with them being there. But there's hundreds of families in the area that won't have that option and who have not been notified about that pipeline. I spoke to the front desk at Country Oaks Mobile Home Park, which is right across from it. The worker who's been there for 7 years didn't know anything about carbon capture sequestering pipeline that is on their property. It goes underneath their property. And for them to state that people have been notified about this meeting, I just find that it's hard to notify everybody who is properly affected by this, especially those who have children who are going to be playing on these structures occasionally and riding four-wheelers and other things across that because there's not enough monitoring and safety regulations to keep these areas protected. To wrap up, I'm requesting that the transfer of the existing certifications of public convenience of necessity not go forward and should be denied, especially until stricter regulations, stricter enforcement of safety standards, harsher repercussions both financially and legally for their companies and their operators. I also do have one other question. Actually, I don't, because I can't remember it right now. I have to write it down. I apologize.
I do have a quick question for you. You mentioned a gas leak near Gillis School. Do you remember around what time the date of that?
September 3rd, 2024.
Okay. I just wanted to look into it. Thank you. Thank you for your comments. What next is? I'm waiting. Yes.
Lisa, we can make this slow. Pardon me.
State your name for the record.
Sure. My name is Sheila Broussard. I'm from Sulphur, Louisiana. My father was in the oil business all of my life until the day he died. My husband is retired from a plant just at Sulphur. I have, my son works construction, he's a welder. Most of my nieces and nephews have some sort of ties to the plant, so I'm not here to try and stop business from business being successful. I did send in concerns, written concerns. What I want to add to that is the safety, and that's the main thing, because in the notification, the safety issue, to say no injuries, well, maybe not in Louisiana, nobody died in Louisiana, but you had mentioned Mississippi. I thought that's where, I believe it was Denbury, had the leak where people were injured. I heard a video of a police officer who came out to that incident, and he said there were people walking along, two people walking along with telephones to their ears and not talking, just walking like zombies. And you couldn't get them to respond to him. So it affected them mentally. And then he was on the radio to the police station, and he could no longer make coherent sentences. So it does affect people in their art. As best I remember, it was a school where some children died from breathing that in. And the people walking, it's because they had to get out of their car, because the carbon dioxide eats away all oxygen. Cars can't run, and people can only live so long without oxygen. And it doesn't float away like some of the other things that might leak out. So that's my safety concern, and my concern that it didn't sound like that in the presentation concerns me.
Right, I'll step in here real quick because they were referencing statistics from the U.S. Department of Transportation's Pipeline and Hazardous Material Safety Administration, which we're a state partner of DOT, and we enforce safety regulations here in Louisiana. We enforce the same regulations that the federal government enforces, and we track incidents and accidents in the same manner as they do. So certainly, in the common phrase of injury, there were people injured because people certainly were impacted by the CO2. They passed out. Those things did happen. Now, the way that the Department of Transportation tracks incidents and accidents and determining what is an incident and accident, there are various criteria that need to be met for it to rise to the level of a reportable incident or reportable accident with respect to pipelines transporting products regulated by Part 195, for which the CO2 line in question transports CO2 subject to Part 195. So what can make it reportable is the volume released, and that certainly it met that threshold. What can make a release reportable is if there is a fatality. Okay, now there was not a fatality with this incident. The other thing that can make an incident reportable is hospitalization. Hospitalization under DOT regulations is defined as overnight stay at a hospital. Not that I went to a doctor, not that I went to a hospital to be treated, but actual overnight stay. So these statistics that they reference are accurate, and that there were no, what PHMSA would call injuries, meaning no one hospitalized overnight. But sometimes there are injuries from incidents where people require some kind of treatment, whether they're burns or other types of treatment that don't necessarily meet that definition of hospitalization, and therefore aren't counted as an injury statistic. So they're accurate in their testimony, and you're accurate in saying that some people were injured by the incident. So I want to clear that up for folks here in the room.
I appreciate that, and I'll go back into the Mississippi accident because I thought there were fatalities. Not sure about that, thank you. Notification, I have a property that, got the packet that this was gonna be taking place, about that thick. I'm not an attorney, so it's a little bit overwhelming to have to look through all that. The notification gave me 7 days before that meeting. So that didn't seem like enough time for me to be able to go through those materials and to get input from attorneys or people more knowledgeable than myself. I believe I'm the first one that contacted Les Farnham about the situation, and then citizens began to get very busy with that. The notification for this meeting was a Facebook notification.
No, ma'am. So the notification process for this hearing is that we generate a legal notice, which we send to the advocate, which is published here. We place it online. We also send that legal notice to the applicant, who has 48 hours to mail a copy of the legal notice and the application to all interested parties identified in their application. Interested parties are those landowners who are traversed, and anyone that they're connecting with, the pipeline, the plant. And so if you receive the notice, you were an interested party, it should have been mailed to you within 48 hours of release. They have an affidavit saying that they did do that. If you didn't receive that notice, please let me know, because then that would be, an issue for us to, you want us to?
And Justin or Lauren can elaborate if you need to, but Ms. Broussard is actually not a true interested party in
Okay.
terms of it traversing her
Okay.
properties.
Okay.
Legal property is Tony Management. Like a legal property is Tony Management.
Yes,
LCM.
oh, thank you very much, it's under my business name.
Yes, and it's not actually traversed by this pipeline. She was inadvertently listed as one with she referenced the original applications, or the 3 applications filed, but upon further review, she is not actually traversed by the
I
pipeline.
got it. Okay. So you found out about it through Facebook rather than a mailing to you because?
No, an official sent me a
Well-
Facebook notice. I asked him who he was and got no response from him. So for this meeting, I got a Facebook notification. My Tony Property Management, property just north of Sulphur, the next door neighbor also got one. So I assumed it was because when the landman called me, that I asked him, some questions, and he said, well, you agreed to us surveying your property. And I asked him when, and it was, I believe he said March of 2025. And I remember getting a call and them talking about, I thought it was drainage, I thought it was the drainage department contacting me. So I asked him for a copy of my agreement. And he said there was nothing in writing. I asked him for a copy of the audio recording of getting my permission. He said that audio recordings weren't necessary because we're adults. And I informed him that I was recording our phone call, and I considered it good business for things to be recorded. So there was no audio recording, there was no written recording of getting permission to come out and do the surveys for this pipeline. So I think I may have, my business, Tony Property Management, it's T-O-N-E-Y, that business got the notification, and the landman called me, so apparently he didn't know that it was inadvertent. I just assumed that I no longer got notices because I rescinded my, verbally, because that was what we were doing, verbally rescinded my approval for them to come anywhere near my property. Thank you so much for your time. Thank you for the information over there.
Thank you. Any other comments?
Good morning, my name is Patrick Riley, and I'm here on behalf of the Louisiana Chemical Association. LCA represents nearly 70 chemical manufacturers across the state of Louisiana. Together, our member companies support tens of thousands of direct jobs, hundreds of thousands of indirect jobs, and anchor the manufacturing base that keeps communities working, parishes funded, and the state competitive. We're here today in support of the application to transfer and amend the existing certificate of public convenience and necessity of the Lake Charles lateral pipeline. This project traces back from approval issued in 2014 and is now moving forward in connection with a major proposed investment in Lake Charles that would convert natural gas into lower carbon blue methanol, bringing jobs, construction activity, and long-term industrial investment in our state. From a siting and impact standpoint, the proposal is exactly what a responsible infrastructure development should look like. The line is planned within an existing utility corridor that already contains significant infrastructure, including more than 20 pipelines and high voltage power lines, minimizing any potential service. And in sensitive areas such as the Exxon crossing, the project is designed to be installed more than 70 feet deep using horizontal directional drilling well below road structures and existing lines, atypical for pipelines, and an extra safety measure. As far as safety is concerned, pipelines are not new in the state of Louisiana. We already live with them, work around them, regulate them, and safely operate them on a daily basis. Federal safety data and PHMSA oversight reflects that pipelines have an incredibly strong safety record when compared to other modes of transportation, and CO2 pipelines specifically have operated in the United States for decades. Incidents are rare on a per mile basis. Louisiana's regulators and PHMSA have already maintained robust oversight over carbon dioxide pipelines with inspection, auditing, integrity management requirements, and enforcement. I'd also like to emphasize operator performance and preparedness. Exxon Pipeline Company operates under hundreds of federal safety requirements governing construction, inspection, monitoring, maintenance, and incident response. Its pipeline system is monitored 24 hours a day, 7 days a week, from a centralized control center with the ability to shut down operations immediately if needed. ExxonMobil has also taken a leadership role in emergency preparedness. The company regularly meets with and trains first responders, participates in local emergency planning committees, conducts emergency drills, and provides hands-on CO2 emergency response training at facilities such as Louisiana's Fire Emergency Training Academy or FET. ExxonMobil has long been a valued member of LCA and is actively engaged with us in safety initiatives, workforce development, and community outreach across Louisiana. The company's sustained investment in safety, compliance, and community partnership reflects the type of operator we want building and maintaining infrastructure in this state. These reasons, the Louisiana Chemical Association supports the transfer amendment requested in this docket, and we respectfully urge the department to approve the application. Thank you for the opportunity to provide some comments.
Thank you. Please state your name for the record.
My name is Cynthia Ramachandran. Thank you for hosting this hearing. I'm the staff scientist at Earth Justice. The information provided in the notice and the application is woefully lacking. Locals, as you've heard, are relying on this information to understand the risks and the impacts from this project on their communities. But the state failed to do an environmental review that is required by the Louisiana Constitution. The application itself is missing even the most basic information that the state would need to do this review. The agency has not even provided a clear and up-to-date map. We've asked. People should be able to see exactly where the proposed pipeline would be. Instead, there's a grainy, low-resolution map that keeps residents guessing about where the pipeline location actually is and its potential impacts. The greater Lake Charles area is already highly urbanized and industrialized and has been experiencing population growth that outpaces both the state and the nation. Based upon the grainy map provided, it appears that the CO2 pipeline would go through or near industrial facilities, as we've already heard, right next to the Sasol rail yard, precious wetlands and waterways, residential and commercial areas, we've already heard about that, as well as under I-10 at a very high traffic point that allows commuters to go across Lake Charles and to drive to and from Texas. Also, I don't think on the application they actually indicate that it would be 70 feet deep with HDD, so that's information that is opaque to the, a high-pressure gas pipeline in such an area would be dangerous. An environmental review is necessary here because CO2 pipelines present huge risks. I don't have time to get into them, but you've heard about a couple of them. When a CO2 pipeline bursts or leaks, it displaces oxygen quickly, meaning you can get dizzy, disoriented, and even suffocate. In this application, there are no emergency preparedness plans, no safety requirements, no information on the location of the important control valves, no leak detection information, no wetlands impacts information, the list goes on. There's no indication that Low Carbon Logistics has consulted with local first responders in the application. I haven't just heard about it. There is no evaluation of how pipeline rupture could impact areas near neighborhoods and the busy I-10-210 intersection. And what I mean there is a rupture model. Lake Charles has suffered enough from preventable industrial incidents, for example, the chlorine accident in Westlake after Hurricane Laura, as well as the CO2 leak that was very close to where the pipeline would connect, near Bankers Road, that was notified only by Facebook. The agency should learn from these accidents and keep these dangerous pipelines away from high-risk areas, or at the very least, require modeling to determine the scope of impacts to residents in case of leaks and ruptures. We urge the agency to deny the application as is and do the review that is required by law. Earth Justice submitted written comments yesterday on behalf of several groups, some of whom are here. Vessel Project, Micah 6-8 Mission, Healthy Wealth, and For a Better Life. Thank you.
Thank you. I just want to be clear, this hearing is not for a permit to construct. It is for a certificate of public convenience and necessity. Our agency actually doesn't issue permits to construct pipelines. Those may be done by other agencies. And I would assume that during the permitting process, some of the information you were looking for would have to be required, but I can't speak to that because I'm not an expert on those, what those agencies look for in those permit reviews. But thank you for your comments. Please state your name for the record.
Yes, thank you. My name is Todd Offerting, representing the Louisiana Mid-Continent Oil and Gas Association, which represents all levels of Louisiana's energy industry that has thrived in our state for over 100 years and is raising Louisiana families out of poverty and serving as a foundation for the success in our state. Today, the energy industry and projects like the one being discussed here support over 300,000 jobs in our state, not just helping our communities prosper, but creating the economic opportunities that keep our kids here in Louisiana. The pipeline that we're discussing would be constructed in the future to support Lake Charles methanol. That project alone is estimated to create 11,000 construction jobs over 4 years and over 400 high-paying jobs over the utilization of this line. It's important to acknowledge, as we just discussed, that a certificate of public convenience for enhanced oil recovery, which we have for enhanced oil recovery, which we conduct in Louisiana safely for decades, does not authorize construction or operation of the line. A separate hearing, as was mentioned, and approvals would be required for that and for the use of this line to support any other use like carbon sequestration. Just once again, I want to reiterate that and appreciate the conversation, but I also appreciate the opportunity today to speak to the importance of this project and voice our support. Thank you.
Thank you, and I do want to correct a statement I just made, because I'm so getting used to being part of the Department of Conservation and not the Office of Conservation. So the department does permit pipelines in the coastal zone through our Office of Permitting, which used to be our Office of Coastal Management. The agency, if this enters into the coastal zone, there would be a permit filed with this department to be handled by the Office of Permitting. Anyone else have any comments, ma'am? Please state your name for the record.
Cindy Robertson. My organization is Micah 6-8 Mission, and we have submitted comments, and I would like to know, where are those comments housed so we can see them online? We haven't been able to find them.
Right, we don't placed the comments online as of yet. I had that question yesterday from our legal staff. But they will be part of the public record. There will be, testimony will be transcribed, the application, everything will be in a docket, that is available through public records requests. We're not yet to a point of putting these online yet, but it's something that we are working towards.
Thank you. Okay, I have to agree with the commenter earlier, and ask the question of what public is this convenient and necessary for? Certainly not those of us who will bear the brunt of the health, safety, and environmental risks in this. And while my organization has filed comments and supported comments of others filed, I'm speaking on a personal level here. When I review the information given to us, it seems like the environmental impact and the public safety study were done in one of the many iterations of Lake Charles Methanol 2 in 2013. And now this is a different route, which we don't really know what that route is because you can't tell from the map that was submitted. So we have no idea if everybody has actually been notified because we don't know exactly where it's going. That 2013 study doesn't include today's demographic information. And I live near where the Green Line CO2 pipeline ruptured in Sulphur in 2024. I didn't find out about it through any emergency response measures. I found out about it on Facebook. I was terrified because of the lack of information. While it's wonderful that the lines are going to be buried 75 foot deep, where these pigs enter the pipelines, all that stuff is above ground. So there are intermittently spaces where this pipeline comes above ground and that 75 foot protection is non-existent. As a concerned citizen, I attend the local emergency planning committee in Cowichy Parish. I am really glad to know that there's now a training going to be held. As of the last meeting in 2025, the emergency response personnel that attend that meeting, police, fire, were very clear that they had no idea what to do or how they could respond to a CO2 release in our area. The proposed pipeline, as far as we can tell, is going to be close to a local Walmart that I shop at. Go underneath I-10, thankfully it's 75 foot, and it's going to be close to the church I attend, and all the boat trips I have taken occur at Anthony Ferry Road for that boat launch. So it's really important to me to know what the safety processes are that are in place for emergency preparedness. And not just with the LEPC, but for the community. How is this going to be transmitted to the community, communicated to the community? How will we, as individual residents of Sulphur, know about this? And as I said, I work for Micah 6A Mission, so I'm kind of got some of the nomenclature down and know some of the stuff. I've attended the Pipeline Safety Trust annual meeting for the last 3 years. I now know what a pig looks like. And which is actually a really awesome machine. But at the very least, before you approve this conveyance or readmission or whatever it is, we need to have clearer mapping available to the public so we know where the pipeline will actually be. there should be better modeling done using computational fluid dynamics and dispersion modeling instead of the CHB that is much less accurate that was used in the initial proposal. There needs to be an emergency response plan that the Township Parish LAPC has access to and is verified as being accountable to the communities that are impacted by that, and is communicated to the public, not just that body, which is dismally poor at communicating the emergency preparations for anything. And once those requests, not just the ones that I have made, but the ones that have also come through in the public comments that have been submitted, once those requests have been answered and submitted, and we can review those, then I would request that we have a public meeting in Calcasieu Parish, like I've done before, in the evening, so that all citizens can attend it, not just us old folks that are retired. Well, I'm not really retired. But, okay, so thank you very much.
Thank you for your comments. And come back up, sir. Please state your name again for the record.
That's for, State Record, District 33. Just a quick follow-up. I think it was conveyed to me that the only place this pipeline was gonna be a 75-foot depth was under the interstate. I think everything else was portrayed to be a traditional dig, installation for the rest of the route. It was only the requirement to get under the interstate that was gonna be 75 feet, and I just wanna make that clear.
Okay, thank you. Any other comments? Yes, we read it from the. Please state your name for the record.
Thank you. My name is Kate Lyon Hunter. I work as the Director of Research and Policy for Rise St. James, Louisiana, where I'm also an in-house attorney. Rise St. James is obviously based in St. James Parish, but this same pipeline operator and this same certificate of public necessity process happened to our community out there. Under the previous system where the landowners were given 10 days notice to show up at a hearing like this in Baton Rouge, they felt left out of the process. People did not know that this certificate had been issued. They did not know that it would result in the fast track process for eminent domain for their land. So I'm here today I'm glad that this hearing had been rescheduled to be a more sane notice of 30 days. But real quick, could Calcasieu residents raise your hand? Was this a convenient place to meet today? No. Are there friends and neighbors, people who were affected by this pipeline who couldn't come today because of where the hearing was held?
Yes.
Should the department hold a hearing in Calcasieu Parish outside of working hours where the same information is presented?
Yes.
Yeah, that's the big gist of the letter that I submitted with signatories from Calcasieu Parish residents who commute, who live, work, worship near this pipeline. And I think we're missing a lot of residents today because of this hearing structure. That's the largest ask that I have, is that this hearing be reheld in Calcasieu Parish. It isn't a permit hearing, as we said, for the pipeline. It's the first step towards eminent domain and seizure of private property. So really the participation of the landowners needs to be first and foremost here. So I hope to see this hearing again in Calcasieu Parish so that we can have full participation. One other thing I'd like to mention, the representative mentioned, is that Denbury and then Exxon have multiple Class 6 permits pending. Carbon dioxide isn't tagged when it goes into the network. Lake Charles methanol is only going to go into the EOR operations in Texas. And like we've said, there's evidence that they are actively seeking Class 6 pipelines. I agree with the representative that the legislative intent from last year was to prevent the eminent domain for private property through CO2 pipelines process unless there's a common carrier application pending. So I agree that this application is deficient because there's no common carrier application pending. Thank you.
Thank you for your comments. You can come back up, ma'am, please.
Robertson. Two things that I wanted to add. One was that I was part of the community group that went to the Sulphur City Council meeting to ask them to not allow the ordinance to even be submitted. And it's kind of like this situation here. We don't want Lake Charles Methanol 2 in our community. It will be right beside our animal control. It's in our community. And if you here deny the public use or whatever it is that y'all call it, public convenience and necessity, then there's no way for them to go forward. And that is what we would like to see happen as citizens in Sulphur. And the second thing is that they notify the landowners, but if you do modeling as to who would be affected by a CO2 pipeline rupture, it is much larger than just the landowners in the area. So I think that particularly for CO2, we need to have a better notification system of all the citizens within the radius that can potentially be impacted by a CO2 pipeline leak. Thank you.
Thank you. Please state your name for the record.
Ashley Stelly. First off, there are just two things I wanted to add real quick. One was the question that I couldn't remember earlier. Like previous people have mentioned, this has been terribly inconvenient for me. My father is currently in Lufkin, Texas, going through a heart cath operation to make him stable enough for an aneurysm clip that we have been waiting for the surgery on. But instead, I am here in an effort to protect my children.
Mm-hmm.
The question that I had relates to the plant that they were talking about. You say that you need this to go forward to continue constructing the plant or something to that effect. Is a CCS pipeline needed for that plant due to any processes that might be done, creating emissions that would exceed the current EPA standards because of the massive amounts of plants and stuff at that area that already do flares and burn-offs?
Okay, so the public comment period is an opportunity to comment. It's not a Q&A necessarily, but I'm gonna ask if they can answer that question. I don't want to, this isn't a cross-examination of the applicant or like that. But if they're able to answer, or that they can decline to answer that question, I'll leave it up to the applicant.
Commissioner, no. I mean, we already heard that the CO2, with EOR delivery and making lower carbon products for markets is the reason for this. But I just want to suggest a lot of these comments were great and for other stages, for other permits. And we're just getting kind of far afield for what we're actually here for today. But I mean, obviously we want to hear them, but no, the answer to the question is no.
Thank you.
Thank you.
Any other comments from the audience? You want to close?
Hey, well, Mr. Ritter, I just want to make sure we clear something up for the record. I know there was talk about the 75-foot. That was in Mr. Rockerty. I'm still in there, so I'm just going to ask you a couple questions to clear this up. When you were talking about the 75-foot deep, was that specifically in reference to this residential area that you saw the public comment about?
Yes.
Okay, and is that an area near I-10?
Yes.
Okay, and so in that area, the pipeline will be buried at 75-foot deep, correct?
Or more, yes.
But in other areas of the pipeline, will it be less covering for the pipeline?
Yes, so follow the regulations governing depth of cover. And so notionally during normal excavation, it could be 4 feet deep. And then at times you'll have to bore under roadways and railways. So it could be notionally 20 feet deep.
And I just want to make sure the record was clear when we were talking about the 75-foot deep, that was in that specific area that the
comment was referred to.
Any other comments?
There aren't any more comments. Mr. Commissioner, we'll close now. Thank you very much for the opportunity to, present the hearing testimony and evidence. And we would just point out that we received a lot of comments today, some of which we tried to address in our testimony. And a lot of it is important and important information to have, but not necessarily relevant for this particular certificate proceeding. I just want to remind everybody that this certificate doesn't authorize any construction or any operation or doing anything, on the ground for the project. Other permits would be needed for that. But because of the volume that we receive, particularly from Earth Justice, for example, 572 pages, at 4:15 yesterday, we've still been receiving some this morning. We wanted to ask if the commissioner could please keep the record open for 3 weeks to allow us to adequately address some of those comments that we've not been able to address here today because of the late breaking filing of some of those.
We'll leave the record open for 3 weeks for any comments on the application, including comments about the applicant.
Thank you very much.
Yes, that's correct. Any comments? And with that, if there are no further comments, we will close the hearing for the day. Thank you.